This meeting of the Senate Judiciary Committee will come to order. Today, the committee will examine the ongoing assault on voting rights and the continued need for the John R. Lewis Voting Rights Advancement Act, which Senator Warnock and I recently introduced with 48 of our colleagues. Before we begin, I'd like to turn to a video that demonstrates why this legislation is essential for our democratic rights protection.
In Selma, only 2.1% of African Americans were registered to vote. The only time you could even attempt to register to vote was the first and third Mondays of each month. You had to stand in line, get a copy of the so-called literacy test, and hundreds and thousands of people would fail the so-called literacy test. One evening, there was a demonstration for the right to vote. Confrontation occurred, and a young man tried to protect his mother. He was shot in the stomach, and a few days later, he died at the local hospital in Selma. We made a decision to attempt to march from Selma to Montgomery, to dramatize to the nation and to the world that people of color wanted to register to vote.
Every American citizen must have an equal right to vote.
It's considered one of the most important pieces of civil rights legislation ever passed. But by 5-4, the U.S. Supreme Court today took the teeth out of a law enacted nearly 50 years ago.
If you go back and read the Shelby decision, it's very disturbing because it strikes as being incredibly out of touch. And we're seeing it manifest so much of what many of us knew when we read that opinion.
And in this moment, we too then are confronted with a fundamental question. What kind of country do we want to live in?
Last week, we commemorated the 59th anniversary of Bloody Sunday in Selma, Alabama. On that infamous day in 1965, 600 Americans, led by young John Lewis and Reverend Hosea Williams, were met by police wielding billy clubs, bullwhips, and tear gas as they marched across the Edmund Pettus Bridge to protest the disenfranchisement of Black Americans. Just months later, Congress finally passed legislation to protect every American's right to vote. The Voting Rights Act, or VRA, passed with 77 votes in the Senate, an overwhelming bipartisan majority. When the VRA was last authorized in 2006, not one senator, Democratic or Republican, voted against the bill. Next year will mark 60 years since the Bloody Sunday and the passage of the Voting Rights Act. But as a result of a series of misguided Supreme Court decisions, there's been a significant deterioration of the fundamental right to vote in America. In 2013, 5 Republicans appointed justices on the Supreme Court dismantled a key feature of the Voting Rights Act by throwing out the formula for jurisdictions subject to preclearance. Preclearance had required states and localities with a history of voting discrimination to submit any changes to voting laws and procedures to the Justice Department or a federal judicial panel for review. Congress repeatedly reauthorized that formula with bipartisan support, overwhelming bipartisan support, in light of reams of evidence demonstrating its continued value. In the days following Shelby County versus Holder, Republican-led states immediately moved to enact discriminatory voter suppression efforts. Voters now wait years for court decisions when they challenge these laws and have to endure elections with these restrictions in place even when they're later found to be violating federal law. In 2021, the court's right-wing majority continued its assault on the Voting Rights Act with its decision in Brnovich versus DNC, creating judge-made, more difficult standards for plaintiffs in voting rights lawsuits. Many Americans fear that this attack on voting rights is part of a coordinated assault on our fundamental rights and institutions, as government officials, including a former president of the United States, try to overturn an election and sow doubt about its integrity. We can restore confidence in our democracy by ensuring that every eligible American can vote without fear of disenfranchisement. Congress can do that just by passing the John R. Lewis Voting Rights Advancement Act, which would restore the VRA. Some have suggested we don't need this law, pointing to record-breaking voter turnout in the 2020 election. But take a close look. And if you do, you'll see the racial turnout gap is actually growing in this country, fueled by these voter suppression efforts. In 2012, the year before Shelby County, the turnout rate for black voters was higher than the rate for white voters in 7 of the 8 southern states subject to Section 5 of the VRA. 8 years later, after the end of pre-clearance, the turnout gap has returned. Black voter turnout has fallen dramatically compared to white voter turnout in these states. Since the Shelby County decision, states have passed 94 restrictive voting laws, including discriminatory laws that the Department of Justice had previously rejected under pre-clearance review. This includes laws that limit the use of mail ballot drop boxes, impose strict ID requirements, cut hours for early voting, and purge voters from registration rolls based on inaccurate databases. Voters in 27 states will face new restrictions on their right to vote in the presidential election. And without the full force of the Voting Rights Act, their rights are at risk during one of the most critical elections of our lifetime. We must pass the John R. Lewis Voting Rights Advancement Act to protect what he called, quote, the most powerful nonviolent tool or instrument we have in a democratic society. Senator Graham is unable to be here at this moment because he's attending the judicial conference across the street. Oh, on cue, he arrives. So let me recognize Senator Graham.